right, section 112. Now we're getting into the meat of this and reforming qualified immunity. Let me just recap the history of this real quick. So after the Civil War, there were civil rights violations going on in the South, and so the Republicans to address this, and they passed a statute. It was known as the Ku Klux Klan of 1871 Act, the Civil Rights Act of 1871, the Enforcement Act of 1871, and it, in simple terms, it gave individuals a right to sue state officers for damages to remedy certain violations of their constitutional rights. And this was, in place for almost about 100 years, and the language is pretty plain. It's exactly what Congress, how they wanted it to work. But in the 1950s, the Supreme Court began to ask whether, well, maybe back in 1871, Congress meant that there'd be immunity in certain cases. There are other examples of places where we give immunity to public officials, like legislators going to and from sessions of Congress. While they're in session, it's a thing. And so the court was like, well, maybe this should apply to police officers too. And so they started doing that they recognized that in the end of the 60s, beginning of the 70s. Forget the exact date. And then after that, then they expanded it. So now qualified immunity means that essentially there's a rebuttable presumption that if your civil rights were violated, the officer had no idea that they were doing so, unless it is well established in law that they should have known better. And so that is what this specific language seeks to address. So what this section does is it adds to Section 183 of Title 42 United States Code, which is the law that Congress enacted in 1871. It adds an exemption. It says, it shall not be a defense or immunity to any action brought under this section against a local law enforcement officer, such as the term is defined in Section 111 of the George Floyd Justice Act, or in any action under any source of law. It shall not be a defense that the defendant could not have reasonably been expected to know whether or not his conduct was lawful. And we've got a bunch of examples of this where conduct that reasonable, rational adults would recognize as unlawful, police officers have been given qualified immunity. When they seized, $200 and some $1,000 in money and rare coins during a search and only reported 50,000 and kept the difference, the rule gave them, the court gave them qualified immunity and said, well, it wasn't well established in law that they shouldn't steal. There's many examples of how qualified immunity has been abused. And it's important to recognize that reforming qualified immunity doesn't automatically make officers who violate civil rights, doesn't automatically make them liable for damages. All that it means is that a court, a jury, can hear the facts and decide. Qualified immunity stops that from happening. And so in order to establish justice, ensure that everyone has greater access to it, it's necessary to reform qualified immunity. Here's the other thing that I just want to touch on is that qualified immunity applies to, under the court's interpretation, qualified immunity applies to lots of public officials. And I just want to point out that this reform only addresses law enforcement. So if there's a question, say, for example, you think the public school teacher who ordered your child to wear a mask was violating their constitutional rights, right now you can't, that teacher would have qualified immunity. And this, from being sued over something like that. And this legislation wouldn't change it. It focuses on where we see the problem and tries to correct it. So I think with that, Mr. Chair, that concludes my testimony for Section 112. and happy to answer any questions.